co this notion of co-employment or shared employment is really, really important. And it doesn't only exist in the code, it exists in common law and in contract law. So your contract could, between you and your customer, could say whose response should say in with you and your customer, who's got responsibility for what and liability for what. And in the absence of it being specified in a contract, it can be argued in common law in court what is normative or normal, and a judge might decide who's the employer for certain aspects of the law. And I just kind of wanted to roll over that one more time for you, because I really think yesterday I emphasized more about what was in the legislation, but want you to know that everything that's in the legislation in Ontario that codifies in statute this the notion of co-employment and and the staffing company being the primary employer is pretty much exactly what happens in every other aspect of law. Unions, collective bargaining, health and safety, workers' compensation, human rights. That's the only difference is in Ontario, they wrote it down. So I kind of wanted to emphasize that too, that it finds its way into other places, not only the Employment Standards Act. Today, we're going to go over some stuff on other aspects of human rights, human resources, and legislation. And I'm going to share my screen. So if you give me 2 seconds, I'll figure out how to do that. And I'm pretty sure that's the screen I want to share. And get back to the okay. So as I described yesterday, we've got a bunch of things that happen at the beginning of these presentations that are the same in all of our CPC certification modules. And because we just did it yesterday, I don't think we need to go crazy reviewing some of the stuff. So I'm going to bomb through it so fast that you won't know what I'm talking about. We've got the 5 modules that we talked about yesterday: legal aspects, health and safety, legal aspects of recruitment, and legal aspects of staffing. Today is recruitment and business practices and ethics, and along with recruitment and selection. Later on in the year, there'll also be a module for sales. We talked about the exam, and remember, the exam doesn't require you to memorize everything. You need to understand the concepts, and a lot of the questions are multiple guess. So you'll get some examples of what the questions look like in our presentation today, where we get to pick A through E or something like that. We talked about the mission statement of the association, so we're not going to review that, but I also am going to emphasize for you that whole point, the critical aspect of a company joining ACSESS is that they got to prove a bunch of things, that they've got workers' compensation, and they've got insurance, and that they have to sign that they're following the law and they do everything, and then they make a commitment to uphold the code of ethics and standards, and that's the real critical objective. In the session that we have, the CPC session on business practices and ethics, we will cover all the code of ethics that ACSESS has. Today, we're going to talk about human rights legislation. We're going to also talk about how other legislations like diversity, equity, AODA in Ontario, and employment equity in the federal government all kind of come together to help us with the various aspects of equity, equality, diversity, inclusion. And then finally, we're going to talk about privacy legislation and what it means as it's related to all those things also. So these are the 4 things primarily that we're going to cover today: human rights acts and laws, employment equity, which is a federal legislation. We're going to talk a lot about diversity and equality and privacy. So first off, human rights describes how we instinctively expect to be treated. So human rights starts with expectations from people and how they want to be treated with dignity and respect and equality. And then the legislation works backwards towards the expectation. So it isn't that some, grand wizard decided how people are supposed to be treated. Over time, we as a society have learned what people have in terms of reasonable expectations with respect to dignity, respect, and equality. And human rights legislation has been written to help codify that into an act or a statute. Now, again, we talked yesterday about provincial and federal legislation because of the jurisdictions that are defined in the Canadian Constitution. So the Canadian Constitution talks about all those industries that we mentioned yesterday: banks, railroads, airlines, telecommunications companies, that they are federally regulated, and that all the rest of us are provincially regulated. And so the federal government has Federal Human Rights Act or code that protects, is applied to the workplaces of federally regulated companies. And the provincial legislation, each province has its own provincial legislation that is pretty much darn similar to the federal legislation. They all learn from each other and take from each other in court cases. I'm going to talk a little bit about how some of it has changed over the years and how it's because of court actions that took place in common law decisions. And so they all kind of follow the same book, and there's differences. There's differences in wording, there's differences in emphasis, there's differences in timelines, in penalties, and how complaints are handled. But the fundamentals of the Canadian Human Rights Act come from the Canadian Charter of Rights and Freedoms, which is part of our Constitution. And then then the provincial legislation looks to the Canadian Human Rights Act and said, what can we get from that? Does it help manifest the intentions of the Charter of Rights and Freedoms, and which is the Constitution, federal Constitution? And then each province puts in its own Human Rights Act or Human Rights Code. So every one of these, whether it's federal or provincial, when it comes to the aspects of employment, they deal with things like appropriateness of the wording of recruitment advertising. Not only the wording of it, but where is that advertising placed, and who is it available to, and how do you get access to it, whether it's on the internet or in a newspaper, in a community center, on a wall. It also covers off referrals. And you say, well, what's that got to do with anything? Well, a lot of times what happens is there's this, I'm going to come to systemic discrimination in a little while, but if we only hire through referrals, it's very likely that we're going to be only hiring like-minded people with similar backgrounds, and we may not have diversity in our workforce. So we look at how referrals are made and what kind of priority they're given. We look at how human rights might affect promotion or demotion, training, wages. Not so much nowadays, because I think people get it, and there's enough opportunity for people to download really great forms and to buy templates and get templates of application forms. But as far back as the 90s and 80s, application forms were like the entire application forms and interviews were the entire focus of human rights. You're not allowed to ask that question on the form, they'd say. That's an inappropriate question on the form. That form is discriminatory. And so I think that nowadays most people get it, and they have good forms, but it also gives guidance as to really, the point not only is it forms, just like, what are we allowed to ask? And even if we're told without asking, what information are we allowed to use and should use or not use in our decisions to hire and fire and promote and train and give set wages and so on. So the same thing goes with the application forms as interviews. It goes as far as things like apprenticeships. Who do we select for apprenticeships? What are we trying to accomplish with apprenticeship? Transfers employees. Really any matter relating to employment. And I think that in a couple minutes, one of the phrases that they use to describe human rights will help us to understand why it's really pretty much every aspect of employment covered under Human Rights Act. So discrimination is an action or a decision that treats a person or a group of people negatively for reasons such as their race, age, or disability. These reasons are what are known as grounds for discrimination. And so we talk about 11 prohibited grounds. And so these are the 11 areas that we are prohibited to use as part of our decision-making process in determining how a person's employment will evolve. And these are all covered under the Canadian Human Rights Act. These 11 areas are race, national or ethnic origin, color, religion, age, sex, sexual orientation, marital status, family status, disability, or a conviction for which an individual has not been granted a pardon or a record of suspension. And so a lot of these things, like number 8 and number 9, 8 marital status and 9 family status, are almost the same, but they're not, because it might be a son or a daughter and not someone who's married. It might be someone who's living in common law, not recognized by some, or maybe the person doesn't recognize them, who's making the decisions doesn't recognize them as being married the same as other people. And so because people don't necessarily recognize these things all the same, they're just not allowed to be considered. And of course, race and national or ethnic origin are similar, but there are some subtle differences. And so they've listed these 11 grounds, and these same 11 grounds are covered within each provincial government's legislation. So it's not important that you, for the purposes of this session or even life or day-to-day operations, have to understand the subtle differences between your province's Human Rights Code or Human Rights Act and the federal government's Human Rights Code or Act. They're mostly administrative and wording differences, but the meanings are intended to be the same. So sexual orientation and the rights of LGBT people were added into these 11 grounds, and I think it's covered, like they didn't make it a 12th ground, so it's all under sex, sexual orientation, marital status, and family status. This is put here because it gives you a really great example of what we've been talking about common law and contractual law and statute law, and it all coming from the Charter of Rights and Freedoms and the Canadian Constitution, how it filters down that big umbrella law for Canada sets the standard, tells us what it's the law of laws. It gives us the parameter that laws will be made under. And so in this case, Egan versus Canada, as far back as 1995, the Supreme Court of Canada held that although sexual orientation was not listed as one of the 11 grounds for discrimination in the Charter, it constitutes an equivalent ground on which claim of discrimination may be based. So those 3 things, family, sexual orientation, and sex, they said, it's pretty much covered inside of those areas. And so it's an equivocal ground. And so, and then in this next case, Friend versus Alberta in 1998, the court held that the provincial human rights legislation that left out the grounds of sexual orientation violated section 15.1 of the Charter. And so they specifically added in sexual orientation into their legislation. So they must have only had 10 in prior to 1998. So then we now have common law. So we've got this charter that sets the standard for the country and all the laws of laws. It's the law of laws. And then we've got specific laws that are not perfectly worded. These are the human rights codes of Canada, and in this case, in Alberta, and for federally Canada and provincially in Alberta. So people challenge it in court. And so the courts decide that they're going to make a decision that is now becomes a common decision or a case precedent. This is, we're going to interpret the statute differently. And so this still means you've got something written that says this, then you've got a court over here that says this means this. Okay, so the statute says this, then the court says, upon consideration, those words mean something that they don't specifically say. So now that becomes confusing, and that opens up the door for more court cases and more people to challenge it because of the slight differences that might occur. And so the federal government comes along in 2000 and cleans it up, and in Parliament passed Bill C-23, which gives things like same-sex couples the same social and tax benefits as heterosexual couples. So things like, can you get the spousal deduction? Can you, transfer your RSPs and make spousal contributions? If someone dies, does the CPP death benefit go to the spouse or the same-sex partner? Well, prior to 2000, it did not go to the same-sex partner. And so, so now the federal government tries to clean it up by becoming more specific, following the charter, following the court's interpretation of what the act means. And then furthermore, in a couple more years later, in 2005, the Civil Marriage Act was passed, which marked a milestone in sexual orientation and equality rights by allowing same-sex couples to be married anywhere in Canada. So again, we had this lack of clarity. We had common law partners, same-sex partners living together. And in some places they'd say, well, you are married because you've been together for 5 years. And in our province and around here, the courts have decided if you live together for 5 years or 2 years like you're married, then you must be married. And other places saying, no way, we're not doing that. Things like insurance companies who are doing group benefits. And they say, well, they're not family, they're a friend. You can't have your roommate. The insurance companies are trying not to cover that person. You can't have your roommate and your friend on there. And so again, the governments come along and they clean it up by passing specific statutes like the Civil Marriage Act in 2005, which says that they have the right to be married. And so if there's any question whatsoever, go get a justice of the peace and get a piece of paper. And boy, there's no more lack of clarity. So there are different types of discrimination that occur. And so when someone enters an area of prohibited grounds and uses that to define the path of a person's employment and decisions of their employment, we take a look, it's called discrimination. And so we look at different types of discrimination and how people might discriminate. So adverse effect discrimination is a policy or a practice that that unintentionally singles out a person or a particular group of people, and it results in unequal treatment. The type of unintentional discrimination is called adverse effect discrimination, and adverse effect discrimination is not necessarily frowned upon, because usually adverse effect discrimination has all the best intentions in the world, and yet it unwittingly or unknowingly results in some kind of discrimination. So here's some examples on the screen. Require an employee to wear a promotional uniform that conflicts with a person's religious clothing requirements. So telling a person that they are not allowed to wear their crucifix, or that they have to wear a particular hat when they might require some other religious head covering. These are real life examples that have been addressed in the courts in the past. So having a uniform that conflicts with religious clothing. Establishing a work schedule. say, for example, I mentioned shifts the other day. You might have the 7 to 4 shift and the 4 to 11 shift and the 11 to 7 shift in a factory, and they rotate, and you do 2 weeks on one shift, and then you get 2 days off, and then you come back on your now on the afternoon shift for 2 weeks, and then 2 weeks later. And it may very well be that some people have got religious holidays or religious practices that take place at certain times of the day or certain days of the week, and all of a sudden it may conflict with them. And so the policy may have been a great policy. This is the way that we're fair to everyone, and we give everybody notice, and we negotiated it through the union, and people get premiums for working at nighttime, and it helps retain employees, and it gives people time off. Might be a great policy, except for it intentionally had an adverse effect on a person or a group of people. So standardizing office furniture. So a company, when I had 32 offices at one point in time in Canada, and we eventually came up with a great model, how many square feet we needed, what the layout of the office is going to be, what the size of every office and cubicle was going to look like, what equipment we were going to buy, and what furniture fit in there perfectly. And then all of a sudden somebody is in a wheelchair and it doesn't work. It doesn't work well for them. Or they've got some other disability that requires them to stand up, or they're injured and they have to have a different kind of chair because of their back. So, refusing a person because you say, nope, that's the policy. And we all know people are like that. Nope, that's the policy. Whenever they want to get their way, they say, well, that's the policy. And there is a policy that defends it, but not accommodating that person. So adverse discrimination is a form of discrimination. It's not necessarily a bad form of discrimination in the sense that it's not intentional. And so when we have adverse discrimination, we can try to accommodate the person or the people, or we can change the policy. So we have another kind of discrimination called systemic discrimination. And systemic discrimination is the one you hear about on the news and in the courts all the time. This is the bad kind of discrimination. This is the kind of discrimination when there's a business practice or a policy or a government program or some hiring, promoting, measurement of performance that systemically or as part of the process and system ends up actually discriminating against a large group or a group of people. So if you said, we're only going to hire from university campuses. We only hire from university campuses. We get college university campuses. We don't consider anybody else. Well, that would be age systemic discrimination, because we all know that the vast majority of people who graduate from college university are younger, somewhere between the ages of 19 and 30, 25, 30 years old, depending upon their level of education and how long it took them to get through school. And so we've now discriminated against 45, 15, 16-year-old people because we're only recruiting and hiring from college campuses. So that would be systemic discrimination. And the systemic discrimination is really something that, and this is why we hear about it on the news, because this is something that human rights commissions really want to pay attention to. So we have this normal way of doing something in a workplace that seems kind of normative, but may have a negative impact on those who are racialized or other areas of prohibited grants. So examples of systemic discrimination, sip time, can include criminal background checks and credit checks. Now, not to spend too much time on this, but it's very possible that a criminal background check and a credit check, they're two different things, that a criminal background check is required, even in law, in certain things, in charities and schools and daycares. It's important that there's a criminal background check on it. It's called a vulnerability check. It goes further than the regular criminal check to find out whether or not there's been any complaints of child abuse or sexual abuse, and let alone convictions. And a credit check, so it would be appropriate, what's called a bona fide occupational requirement in certain jobs to have a criminal background check done. But if you're laying sod, I remember a case I think it was in Ottawa. My company supplied a whole bunch of people to work for a landscaping company for a short period of time. We weren't really in the light industrial or like the labor business, but we supplied a whole bunch of people to help lay sod. And there were like 20 people, 10 of our temps, and not necessarily only our people, but they were taking a coffee break, and there was a coffee truck there, and then a police cruiser came up, and half the people ran away. So that, half the crew wasn't even there anymore. And so clearly, that group of people had something to fear of, probably outstanding warrants for their arrest or something. But the reality is that you don't need to do a criminal background check. Like, I don't think they're going to steal your sod. You don't have to worry about people behaving in a dishonest fashion. Credit checks are a little bit different. Lots of companies do credit checks on people, and they find out that they've got a bad credit rating, and then they disqualify the individual from being hired because, if you can't manage your own credit card, you can't work for us. Somebody has turned on their microphone. Whatever it is. Making really crazy speaking noise. Okay, that's gone. Thank you for turning off your microphone, whoever you were. So criminal background or credit checks are a little bit precarious because criminal background checks, people are doing background checks on people's credit ratings, and they have nothing to do with the job. They're not, handling other people's cash. They're not being trusted with bank account information. They're not having to carry money around. Like, I'm not really sure in a lot of cases what a person's criminal or credit background has anything to do with whether or not, they can type quickly or accurately or write or code for a website or something. But companies check credit, and then they eliminate people based upon the fact that they've got bad credit backgrounds. So having credit checks for all jobs or criminal background checks for all jobs would be considered systemic, because they're likely this information is being used for reasons that don't make any sense. Recruitment practice such as favoring or limiting to word of mouth. So I talked about that earlier. If you only use referrals and word of mouth, you tend to only hire people from the same families and similar backgrounds. And as a result, you don't end up with a diverse workforce. And so you're systemically, unintentionally, and unwittingly discriminating against all the rest of the world. Steering of applicants to certain jobs or assignments based upon race or gender. So this happens all the time. And my goodness, we see this even happen in high school guidance counselors. We hear horror stories of high school guidance counselors telling people that they should pursue a particular career. And it's really uncanny and unbelievable how, at least in my day, those guidance counselors were sending people down gender-based paths that had very little to do with wants, desires, fears, capabilities, knowledge, expectations, wishes, dreams. And it was very often just based upon some assumptions about race or gender. Historically segregated occupations or industries. I think I've just kind of addressed that. I could go through the list. You can see them. There's job ads and customer preferences. We have a problem in our home care business in that many clients have Alzheimer's or dementia or other related dementias, and many of them have English as a second language or no English, and they have real difficulty in understanding. They have difficulty understanding no matter what because of their disability. And then we have got caregivers and nurses that are very often new immigrants to Canada, and some with very heavy accents. And so we end up having this person with dementia telling us that person can't work here anymore. And so with all due respect to the patient, the least qualified person who can't remember what they had for breakfast, and part of their disability is formulating decisions which are very often discriminatory about the most competent and qualified caregivers, nurses, and healthcare workers. And so customer preference can play a heavy role in it. And it's really important for us as employers to try to figure out how to navigate through that so that we respect the dignity of, the expectations of, and the equality and the opportunity for our employees. But on the same token, it doesn't make any sense to supply a person or send a person to a place where they're going to be harassed and abused by the client, because the client either in a corporate environment would be doing it wrongly, and in my example for home care, would be doing it without any ability to control their behavior. So to try to find these balances are often a difficult challenge. But keeping in mind that allowing customers to make decisions on an ongoing basis without your influence in it can definitely mean systemic discrimination if the customer is discriminated. Algorithms, big data. Hi.
Yeah, so taking to the third and the fourth point, right? With us in the home care industry, just as you were explaining, let's say with the gender issue, for example, you have a female that needs care and the family says they want only a female caregiver. Like putting out a job posting and saying you need only a female caregiver, is that okay?
I don't know what the courts would say. In my company, we have said that whenever a person tells us that they'll only have a particular gender, then we first off consider, if it's a man saying I'll only have a man, or a woman saying I'll only have a woman. But if we have, then we take it to the next step. If it's a man that says I'll only have a woman, or a woman say I'll only have a man, we say, sorry, you're not allowed to do that. Like there's no grounds for that. Like you can't use, personal privacy, and, this is a health related issue. These are professionals, you can't do that. But if a man says he'll only have a man, or a woman says they'll only have a woman, we take a look at two things. We take a look at, one, is it based upon something to do with their culture or religion? And if the request is based upon their culture or religion, then we need to, for the purposes of human rights, respect their request and not be overly assertive in telling them they can't make that request. If it's what it most normally is a person saying, I don't feel comfortable having a person of the other gender, taking care of my personal needs, my personal care and personal hygiene, then we try to talk them through it. But at the end of the day, we have to consider the fact that it's not fair to our employee to send them to a place where we can reasonably expect that they will not be treated well. And so at the end of the day, while the request may be inappropriate, we also have to take into consideration this person has an illness, often not capable of making decisions, often in such a stressful situation because of their illness or their cognitive disability that they can't manage and control it, and we can't rationalize with them. And so we look at both parties, and so sometimes we can convince them that this is the right thing to do, and they accept it and everything works out. And sometimes we come to the conclusion that for our employees' benefit, it's not in their interest for us to put them into a place where they're going to experience discomfort and harassment. So we'll place that employee somewhere else and we'll accommodate the customer. So I think it's nuanced. It's new. I don't think we can honestly say in every healthcare situation, it's not okay to make a gender request as a bona fide occupational requirement. And I don't think we can say in every occasion we have to disregard it. So it is nuanced, and we really do need to look at both employee and customer to respect their human rights, their dignity, and their respect, and respect them. And I trust that most people will make the right decision. But you're not going to get a question about home care and healthcare on your exam. But that answer I gave you is really to help you in real life.
Okay, thank you, Steve. I was just asking in the case that, like, can a caregiver sue you for discriminating, like not wanting to send them somewhere when you know that these are the factors hindering you from sending them, right?
Well, I don't.
Can they sue you for discriminating?
They could, but I don't. In my company, I don't think that they would, because we have hundreds and hundreds of caregivers and nurses and healthcare workers and hundreds and hundreds of clients. It's a matter of just moving people around. And we would say to somebody, I don't want to send you there because they're going to treat you badly and they speak mean and say bad things and they're going to make you feel uncomfortable. I want to send you someplace where you're going to be happy, and they're going to respect that and appreciate that. They would probably sue me if I forced them to go to a place, that they were treated that way. So in my case, I don't think it's going to happen. It's more likely to happen in a one-on-one case where, like where a family hires a person directly and then fires them or treats them badly based upon their gender or race, where they don't have the opportunity to move people around and, try to accommodate things. Hey, at the end of the day, if you've got a customer knowingly, wittingly, intentionally disregards human rights, treats people badly, and harasses them, you fire the customer. In which case, the employee doesn't, if that's the only work you have, the employee still doesn't get work. So finding the solution that treats people with dignity and respect is the way to go about it, right? There's no law against being a racist or about being a bigot, or there's only laws about it affecting employment and affecting housing and affecting opportunity in commerce, in retail and restaurants and stores and services. But, there's always going to be racist people, and you just fire them. If at the end of the day, you just fire them. And, I've been around the business for a long time, and I've done hundreds of millions, probably been involved in close to $1 billion worth of staffing. And I've had a very small handful of cases that have been unresolvable and the customer needed to be fired. Very small, maybe 6.
Steve, just to make a comment, as for myself being a woman, if I was in the healthcare industry, or let's say I was a patient, I would probably ask for a female only because of the comfortability of having a female. So by me asking for a female, because I'm a female and I would rather work with the female, only because, who knows, depending on the situation, maybe they help me to the bathroom or, dressings and stuff like that. Would that be considered discrimination as well?
No, you see, if because of your gender, you have cultural and personal beliefs that your privacy and personal dignity is being violated in a way that makes you feel uncomfortable, you can make the case that this is a bona fide occupational requirement. In many of those circumstances, when we talk to people about what they're going to do, what the job is, how they're going to do it, how they're going to respect the person's privacy, how they're not going to see them without their clothes on, or how they handle things, then we can very often resolve that and get people through it, but if it's unresolvable, then it's bona fide. Like if you can't accommodate it, then if you can't find a way to accommodate and make it work, then you shuffle people around.
It makes sense.
Okay. But I got to tell you too, like, when it comes to that particular issue in this example, we're into a very, very unique aspect of human rights laws that, again, is very nuanced. Like back in the 1970s, there was an issue with respect to female reporters going into the sports dressing rooms before and after the games to interview players. And, a lot of the NFL teams and NBA teams were refusing to allow females into the dressing room to do interviews. And it went to court and they fought it out. And the men said, I don't want a woman seeing me in the shower, or I don't want that. And so the courts came to a concession saying that teams are required to provide an area that's not right in the dressing room so that female reporters could interview male athletes and vice versa. Male reporters could interview female athletes without having access to the dressing rooms. And then, of course, you get idiots like Donald Trump, who during the world pageant that he owned and operated, where he just wandered through there. And then, there were all kinds of court cases and accusations of discrimination because, he didn't see what the courts were deciding. So the courts said, this is okay. This is a reasonable request, to not be seen without your clothes on. But, the reality is for most of us, that's not what we do, right? We supply engineers and administrators and software designers and accountants. And so, that particular issue becomes extremely nuanced, and it's interesting to talk about because it can be argued both ways. But that's not, what we deal with most days, day in and day out. And I think the answer is, you do not accept discriminatory job orders, knowingly accept discriminatory job orders. You do not put a person into a position where you have a reasonable expectation that they will be treated badly, harassed, humiliated, offended while they work there. And so we have to respect the needs of our customers and particularly of our employees. Okay, so there's been some questions about psych tests. I'm not sure. I think psych tests, psychometric tests, personality tests, assessments are so sophisticated now that they can prove that they really don't need assessments based upon gender or nationality or culture, that they just simply tell you, are you passive or aggressive, or are you outspoken and sociable, or are you demure, and there's certain jobs that those are, make you better at. You're a better salesperson when you're outgoing and outspoken and assertive and energetic, and you're a better scientist if you're more linear thought in your thoughts and you take your time to check each step in the process and you're detailed and accurate. So the great salesperson is writing things down on the back of the business card, and the scientist is doing things 7 times over to make sure that they're perfect. And so personality tests have been questioned, and I think some of them challenged, but I think they usually make the cut. Physical ability tests, you've seen them before. You've seen these issues before, like how do you become the firefighter? Can you carry 40 pounds or 140 pounds on your shoulders like a set of stairs and back down again? So they've come up with job descriptions and ways to accommodate that if you can do everything except for that one thing, you don't get to pull the hose into the fire. There's different ways for them to deal with it. There's capacity tests and cognitive tests, which are IQ tests and math tests and spelling tests and Word and Excel tests. And these are all fine, except for, if you've got a person who's going to work in French and they learn in French and they speak in French, and you give them an Excel test in an English version of Excel, that could be a problem. There are some employers that have mandatory religious practices. So for example, I'm not sure what the status of it is right now, but the Catholic schools at one point in time would only hire Catholic teachers, and they would only hire Catholic teachers who got a letter from their priest saying that they were good Catholics, and even, I don't know, my daughter's 33 years old, and when she became a teacher 10 years ago, we took an envelope out. She hadn't gone to church near our house in a long time, and we were always away skiing on the weekends in Collingwood, and she was off at university and not in Toronto. And so now she's applying for a job in Peel region. So, we go and get her an envelope in her name and make donations for 4 or 5 months every week. And then when she goes in to see the priest to get her letter, he can say, oh yeah, you're a regular contributor to the church. I don't think that was right. And it wouldn't necessarily pass the test for discrimination, except for when the school board says there are certain aspects of the curriculum that are very specific to Catholicism that you must know. And unless you can prove that you have knowledge of those things, you can't be a teacher here because you can't teach that course or you can't teach that part of the curriculum. So, they've kind of got away with it a little bit. But typically what happens is that, there's a group of people of a particular religion that all work in the same place, and there might be an underlying religious theme to the charity or to the social service or to the organization or to what they produce, what they make, and or sell or service. And the reality is that it's pretty difficult to prove that you have to be of that religion in order to make that kind of cake. These are examples of systemic discrimination. Boy, I spent a lot of time on that. I told you I'd be quick today. So other things are things like age-based limits, mandatory retirement, waivers that may prevent employees from filing complaints because of things. These are all systemic, no fault attendance policy. We have zero tolerance. You come in late, we lock the door. You can't come in. We have no tolerance. You miss 1 day of work, you're fired. Or 2 days of work, you're fired. I don't care why you were late or why you were away. Doesn't matter that your child was sick or that you crashed and broke your leg. So those kinds of policies are considered systemic and they're inappropriate. Light duty policies for only work-related injuries. Oh yeah, so a person gets injured playing hockey on the weekend or whatever, skiing on the weekend or walking up their stairs, slipping in the bathroom. And the company says, well, that's not our fault. So we've got no obligation to accommodate you with light duty. Well, that's not true. That's discrimination. Pre-employment medical ones are a great one for lawyers, law students to argue over, because clearly there's certain things, like having a heart defect and having to lift heavy things, and your doctor tells you you can't lift heavy things or you'll probably die, and then they come and apply for a job to lift heavy things. So there's certain things that are pretty straightforward, but a lot of times these medical inquiries also get into areas that shouldn't eliminate a person from doing their job or being hired for their job, but the information gets to the employer and they, in their personal mind, think, oh boy, diabetes, yeah, no, you can't work here. You're going to blow up our healthcare system or our health benefit system, or, which is not necessarily true. It's not true. They don't know that. And so pre-employment medical inquiries can be discriminatory, and in certain cases, they may not be discriminatory, but doing them blanket across the board absolutely is systemic discrimination. So I've talked about these two types of discrimination, adverse versus systemic. So adverse discrimination may be a good policy that may unwittingly or unintentionally have an impact on a person or a certain group of people. And that policy may be, can be kept in place, and you just need to give accommodation to the person because it affects a person in a way that was not intended. So let's just treat them, give them special consideration on this one. So adverse discrimination, we want to consider a better policy, or we want to consider some tweaks to the policy, or whether we can accommodate the person. Whereas systemic discrimination is not a good policy. It may not have been intentional, and it may not, they may not have noticed or known, but once they become aware of it, that it regularly influences or causes a discriminatory result, then the policy or the practice needs to change. So I've used the word accommodation a lot. So and we talk about accommodations and reasonable accommodations, because there comes a point in time where accommodating an individual's needs can become unreasonable. It doesn't make any sense anymore that we got to go that far. You know, it might be okay. It's perfectly reasonable to put a ramp into a workplace, but it's absolutely unreasonable to take a short-term lease for 6 months on a place, have no intentions to be there after 6 months, and go out and spend $140,000 on an elevator. So, you know, one is reasonable and the other is unreasonable. And so the reasonable accommodation may not be the elevator. The reasonable accommodation might be that you get to work on the ground floor, or you get to work from home, or something, until it comes a point where there's just no opportunity to accommodate. So we talk about reasonable accommodation. And so things like, you know, if you're seemingly discriminating against Aboriginal people because, you know, there's a 5% Aboriginal population in this area, but we don't have 5% of our employees, or even one, why don't we accommodate them by that particular group by running some jobs specifically in the Aboriginal communities, or Aboriginal Friendship Center, or in the Aboriginal newspaper, or, you know, putting things in a different way in the newspaper, specifically identifying, you know, that you'd like to find some Aboriginal people because it's helpful. My company advertises for people of different languages all the time, because we have Greek and Chinese and Portuguese and Italian and Spanish speaking people who are older and ill, and they, in our home care business, and they can't understand English. And it's frustrating for a person, not only with maybe, you know, no English, but also with dementia and also suffering. So can we get somebody who can at least understand what they're asking for a glass of water, or that they're uncomfortable in their bed? So we constantly are advertising in different languages, for different people with different languages. You write the ads in different languages, and we say in every ad, you know, there's greater opportunities for people with bilingual talents because of the needs of our clients. And so we encourage people with different language to apply, not discourage people because they don't speak English very well. So, you know, apprenticeships program, installing software or features, putting in voice recognition software, or enabling somebody to have larger fonts on their screen, or having Braille in the office. These are all reasonable ways to accommodate different keyboards. These are all reasonable ways to accommodate people. Changes in schedules, and we'll come to some examples there. So there's this term, Latin term, bona fide. Some people say bona fide. My university professor said bona fide. Occupational requirements, or a bona fide occupational qualification. So we tend to see a bona fide occupational requirement tend to be the more traditional term in Canada, and bona fide occupational qualification in the US, but it's exactly the same thing. So if you see BOFQ or BOFR, or bona fide occupational requirement qualification, it's exactly the same thing. And this is when there is a criteria in hiring that on the face of it may look like it's associated to a prohibited ground, one of the 11 areas of prohibited grounds, but it's allowed because there's just no getting around it. So for the questions, the complicated questions and the nuanced questions you gave me about, gender discrimination with a female client and a female caregiver, that could be considered. If the answer is yes, that's absolutely reasonable. And we just can't have a man go into that situation. The client will have a nervous breakdown. Then why you're not going to cause a client to have, emotional distress and, reaction. So, that can become a bona fide occupational requirement. A real interesting example, which I've made up, it's never happened, is when you've got a historical building that is like 400 years old and the walls are 3 feet thick. Let's say it's a prison, from the 17 and early 1800s. And in order to get in and out of it, you have to go, they intentionally made it. So you got to go through them once you come out of the locked doors and things, you're going to go through a little bit of a maze. And then between these two walls that are only this, or you can see me, that are only, 12 inches apart. And everybody goes in and out and has to turn sideways and slither through there so that if anybody were to ever escape from their cell, that the last part of the maze, after they've, fought off all the guards and done everything else, that they have to turn sideways and slide for 12 feet down the skinny path while the people with their muskets at the other end can just sit there and stop you from getting out. So imagine that's the system. Now, by the way, I kind of made it up, but I went to, I think it was the jail in Toronto that's now part of a rehab center in Eastern Toronto. And part of the jail was sort of like that, really skinny doors and pathways, but not that skinny. But in this example, so if we're going to give historical tours and hire customer service representatives to give tours, and we can only let people who are 12 inches wide go in or come out, or people that don't have some phobia about being in closed places, those are two occupational requirements. That you can't have a illness or a phobia about going into narrow, small places, and you need to be skinny enough or not wide enough to fit through there, or else you can't take people in. You can't, and furthermore, some customers can't get in there. And maybe the place is covered under some sort of Heritage Act where they can't actually blow a hole in the wall over there and give people the other access. Now, nowadays, they would. Anyways, they would say, hey, we have to accommodate people, and for safety and fire, we got to go around the back and put a hole in the back wall and destroy the heritage aspect of it, but let's just say they couldn't. So there you go. You've got this really crazy example of something where you just can't let a person, and they do the same thing for rides for safety reasons. They say you can't go on the ride unless you're this tall. It's a bona fide occupational requirement that you can't be the person who tests the ride unless you're also that tall, because it's dangerous to go on there. We're not going to put your life at risk. So there are certain things that are really obvious in the crazy example I just gave you. And there's some things that are not so obvious that it's a bona fide occupational requirement. So for when we get to some of these cases, usually people argue. That's what the argument is over. Is that a bona fide occupational requirement? Is that really something that you couldn't have reasonably accommodated? Did you have to put in a $200,000 elevator in the 6-month lease place? Did you have to blow a hole in the wall and you couldn't have given me the job? Me, the fat guy, the overweight person, because I am, selling tickets instead of giving the tours. Is there no way you could have reasonably accommodated this? So the argument is usually over reasonable accommodation and bona fide occupational requirements and how those go together. So here's a case. Mr. Christie was employed at the Dairy Pool and became a prospective member of the Worldwide Church of God in 1983. The church recognizes a Saturday Sabbath and 10 other holy days throughout the year. As members of the church, they're expected to not work on those 10 holy days. And Mr. Christie asked his employer for permission to take unpaid leave on Tuesday, March the 29th, and on Monday, April the 4th. So I think we're looking at Good Friday and Easter here. So or around that time, because both days were holy days in his church. He was granted leave for the Tuesday, but was denied leave for the Monday. So because Mondays were especially busy for the dairy pool, milk that arrived over the weekend at the pool must be processed promptly. So remember, this is 1983. So the milk's coming in these uncooled containers, and they got to process it right away and pasteurize it and get it packaged and out the door, or else the milk's going to go sour. And I'm pretty sure nowadays they have ways of keeping it cool. But in 1983. So when Mr. Christie was absent on Monday, April the 4th without permission, his employment was terminated. I'm not sure if nowadays most employers would terminate a regular employee after 1 day of absence, but this employer did. So the Board of Inquiry was called because it went to the Human Rights Board of Inquiry, and they ruled that Mr. Christie was discriminated against because his religious faith had not been accommodated. Then this decision was overturned by the Alberta Court of Queen's Bench and the Alberta Court of Appeal. And then, by the way, later on, it went to a Supreme Court and it was overturned again, and the lower court found its way. And so they basically said in the beginning, the court said, yeah, it's 1983. We have no way to deal with this milk. If we don't process the milk, then it's going to go sour and there's going to be thousands or tens of thousands of dollars worth of damage done. And you didn't show up for work and you caused tens of thousands of dollars worth of damage. And so, or more. And so that was the original decision. So the Board of Inquiry found that the employer had made so when it was overturned eventually, had made no significant effort to accommodate the request and was fatal to the establishment of a bona fide occupational qualification. So in other words, they failed to say that it was a bona fide occupational requirement that you must always work on Mondays. And the principal question raised in this appeal was whether the particular attendance rule imposed by the employer on the employee is a bona fide occupational requirement. So this would be considered religious discrimination under a systemic discrimination policy. So let's take a look at another case. So this case is the CNR, the railroad. And in, again, 1980. Now, a lot of these cases are really old because I'm giving you the first cases. There have been lots of cases since, lots of subtle differences that occurred, in cases that found their way into court. But they typically rely upon these decisions in order to go forward. So in 1985, a precedent-setting case, the Supreme Court of Canada decided that the requirement of wearing a hard hat was not a bona fide occupational requirement and amounted to discrimination on the basis of religion, which entitled a Sikh worker to continue his employment without having to wear a hard hat. So sometimes you might say, hey, you got to wear a hard hat. And your religious headdressing just doesn't provide the protection that you need in this particular case. There's this thing that whizzes by your head every 5 seconds, and people get hit in the head all the time. So imagine it. Let's change the scenario and say, imagine you're a football player or a hockey player, and you say, yeah, no, my religion says that I have to wear my religious headdress. I can't wear a helmet. And the NFL is going to say, no, sorry, policy, rule. Everybody wears a helmet on the field. Even if your strap comes undone, you get a 10-yard penalty. And if it happens twice, you get kicked out of the game. And so for safety reasons. So imagine this was a football player. It would be pretty difficult to come up with a scenario where you could play football with a bona fide occupational requirement without wearing a helmet. But in this case, with the CNR in 1985, there was no shortage of maintenance electricians. This gentleman was a maintenance electrician. There were many of them. Mr. Binder was not unique. So he wasn't the only guy. There were other people who could do all or parts of the job that he did. The employer's safety policy would not be jeopardized by giving Mr. Binder an exemption. In other words, believe that everybody now is going to ask to not wear or demand to not wear a helmet, because Mr. Binder was given special consideration. Mr. Binder was willing to relocate to a post or a location where a safety helmet was not a real necessity. So it wasn't a football field, and there wasn't a swinging thing by his head all the time. And that he was not willing to assume duties other than those of a maintenance electrician. So he was saying, I'll only be a maintenance electrician, but I will go to other locations around the company in order to do my work. Mr. Binder was able to perform effectively and efficiently without a safety helmet, so it didn't affect his performance. And Mr. Binder's fellow employees, nor the general public, would be injured by Mr. Binder not wearing a helmet. So in the, I don't know, I'm not sure how somebody else gets injured. Let's say, for example, one person's the safety person and the other person's on the other end of the rope, and the safety person who holds the rope is not wearing a helmet, gets hit in the head, and then lets go of the rope, and the other person falls to their death. So there would be an example to their injury. So there would be an example of how one person not following the policy could affect the safety of another person. So in this particular case, they found no such circumstances. So the risk of injury to Mr. Binder if he did not wear a safety helmet was if he went to another location, did the different type of electrician's job, was very negligible. So in this particular case, they determined that they should and could provide reasonable accommodation for his bona fide occupational requirement. So the reasonable accommodation, it's reasonable to put him in a different place, to allow him to not wear a helmet, that did not have a specific risk, allow him to keep doing the same or similar kind of job as an electrician, not putting him or anyone else at risk. This was very reasonable. And his request, because of his religion, was real, bona fide. So he had a bona fide occupational requirement that was accommodated. So which of the following, so these are the kinds of questions you get on your challenge exam, by the way. Which of the following is not a discriminatory practice? Denying someone goods or services, facilities, or accommodation based upon prohibited grounds. Well, of course, that's discriminatory. Denying an employment opportunity based upon a bona fide occupational requirement. No, that is not discrimination. We are allowed to select people based upon a bona fide occupational requirement that could not be accommodated. Paying men and women differently when they're doing work of the same value. Of course, that's discriminatory. Retaliating against a person who has filed a complaint with the commission or against someone who has filed a complaint. So this is a reprisal. I mentioned reprisals yesterday. So retaliating against a person who had the right to complain. Whether or not they actually succeeded or not is irrelevant. If they thought that under the law, their circumstances would be covered, then they have the right to complain. Now, of course, we argue over whether that's a bona fide occupational requirement or whether it's not. We argue over whether that's a reasonable accommodation or whether it's unreasonable. We argue on whether the law even applies to the complaint that they have. But while they're making the complaint, they have the right to make that complaint, and they cannot be punished for having pursued their rights, even if they fail. Harassing someone is obviously discrimination. There's another case. The Western School District case. Oh, what time is it? We've got 15 more minutes for break. Western School District. In a unanimous decision, the Supreme Court of Canada restores the decision of the BC Council of Human Rights. So the BC Council made a decision. Somebody escalated to the Supreme Court. Supreme Court agreed, which found that Mr. Smith was discriminated against by both his employer and his union. So I'm not going to read this to you. I'll tell you the story. Mr. Smith's a custodian. The collective agreement says that people have to work on Friday nights from 3 p.m. to 11 p.m. That shift that exists. And it's, that's kind of common. Like very often schools rent the school out every Friday night to, Boy Scouts and Girl Guides and other organized volleyball teams and sports teams and whatever community groups. And they have a policy that there must be a custodian on site. And so they have got this standard shift for custodians to work from 3 p.m. to 11 p.m. on Friday nights. And he's part of a union, and the union negotiated this agreement that that's one of the shifts that was there. And because of religious reasons, he was not able to work on Friday nights. And so he requested the time off. They denied it for him. He said, I can't work it. And it resulted in him losing his job, or the threat of losing his job. And it went to court, and the court said basically the same as the electrician. Let's look at this. Is there a reason why you can't assign another custodian? Don't you have lots of custodians? And isn't it a big school board? Aren't there custodians in all the schools? Can't he take the time off? Can't you put him onto a different shift? What if you haven't rented the school out on Friday nights? Can he come in on Saturday and do the work on Saturday if there's nobody there, if the doors are locked on Friday night because you haven't rented it? So they came to the conclusion that the school board and the union who negotiated that deal had not accommodated them. Now, in this particular case, Hockey Canada is in a lot of trouble these days. I'm not sure whether we should even be using Hockey Canada as an example here, but it was one that was put in here several years ago before Hockey Canada got in too much deep doo-doo for their behavior or lack of behavior. But in this particular case, we had a transgender hockey player who filed a complaint because of the facilities at the local arena didn't seem to accommodate the person. And a resolution was made, and Hockey Canada agreed. So it went to the Human Rights Commission. The Human Rights Commission negotiated a settlement, and they agreed that Hockey Canada would provide training to all Ontario-based trainers and coaches on gender identity and gender expression, including training on discrimination and harassment. Now, by the way, a very common negotiated or imposed solution by virtue of an order to comply or a negotiated solution is in the company or the organization saying, we agree to create a policy and we agree to do and provide training. Keeping in mind, by the way, that sometimes organizations don't realize the extent of which they have to go to, and they might end up spending hundreds of thousands or gajillion dollars in putting their training program in place, keeping it in place, and offering it and continuing to offer it on a regular basis to all of their employees everywhere. And so it is sometimes viewed as a form of a penalty. But most organizations look at it as, hey, this is our obligation, and this is what we need to do. And so they agree to provide training to all their trainers and coaches, and also on discrimination and harassment, and that they would amend their co-ed dressing room policy, which would be publicly posted on all of their websites and the Ontario branches of Hockey Canada, to include that a player has a right to use a dressing room that corresponds to their self-identified gender, that a player shall be addressed by other players by their preferred name and referred to by their preferred pronouns corresponding to the player's self-identity, and that a player is entitled to privacy and confidentiality with respect to the player's trans status, and that information about the amended policy and staff and volunteers policy would be available to everyone, players, parents, and staff in the province. So, this on the face of it looks like somebody wanted to use a different dressing room, whether it was a co-ed dressing room or whether it was a gender specific dressing room. I don't know the details. But eventually Hockey Canada came along and said, we're going to respect the person's self-identified gender, and we're going to go forward as if there's no question of what their gender is. Now, it's interesting too that this particular case is in our presentation and has found some place in law because there continues to be with respect to sports, the question of whether transgender individuals should be allowed to play in the other sex in their identified sex level of sports, whether men should be able to identify as a female and play competitively in the Olympics or in anywhere else in a female category. So that continues to be something that I think, to the best of my knowledge, is unresolved. Is unresolved in many sports, not in some sports. It's resolved in some. So this is again an example of the type of things that you're going to be tested on. And once we finish this, we will take a 15-minute break. Maybe we'll get through one more section. So all we're going to do is we're going to match up the question with the thing on the right-hand side. A policy provides a benefit to some married couples, but not to others. This may be a case of discrimination based upon family status. So that might be the example of the same gendered married couple. So that, as I said to you earlier, that would fall under gender or family status. A person is denied, number two, a person is denied a job because of a previous conviction for which a pardon has been granted or a record has been suspended. So that's under pardon convictions. I'm not going to go into real details here, but the law basically says you can't discriminate against a person if it kind of implies that you can use a person's criminal background as a term or condition for employment, except for when there's a specific requirement. However, even if you have a specific requirement, if a person has been pardoned for their conviction and somehow the employer finds out, they're supposed to ignore it, because a pardon basically says, or a suspended sentence, basically says, this never happened. This is expunged from your record. And nobody can use this against you in their decisions to hire you or give you a loan or give you housing. Pardons are rare. They're difficult to get. And for some reason, whether it's just because there's old newspaper articles or people in the community know, or police records are not brought up to date, pardons, convictions still show up in people's records even after they've been pardoned. So the law says that if you do have a bona fide occupational requirement, that means that a person did not have a criminal record, and that yet they have a criminal record, but they've been pardoned for it, you're not supposed to count it. So that's what that is all about. What's the next one? An employee has a reaction to dust and chemicals. So when a person has an allergy to dust and chemicals, this is considered to be a disability. A female employee with an excellent performance record announces that she's pregnant, and all of a sudden she doesn't get the promotion. That is family status discrimination. An employer assigns her employees to weekend shifts without recognizing that some employees observe the Sabbath and cannot work on those days. This may be a case of discrimination based upon, well, we already had a couple examples of that, religion. And number 6, an employer's physical fitness requirements are based on the capabilities of an average 25-year-old instead of being based upon the actual requirements for the job. So they've put in requirements there that don't line up with what you actually do day to day. And so it's not a bona fide occupational requirement. It's a fake requirement. People just want somebody that looks really and acts really fit. So that would be age discrimination. Harassment. We're going to go quickly through this because we're now getting down to 3 minutes. Harassment. So harassment is in itself doesn't fit like the encyclopedia or dictionary's definition of discrimination, but it is a form of discrimination. When a person is harassed, it's considered in the law a form of discrimination because it involves unwanted physical or verbal behavior that offends or humiliates a person. Generally, harassment is a behavior that persists over time. It's a series of incidents, but it can be one incident if that incident is so severe that it will have a lasting impact. So a series of incidents is absolutely harassment, and that has a lasting impact. It's lasting at least for as it's happening, probably longer. And a severe incident is considered also harassment because it will likely have an impact over time or longer. An individual joke or an individual pat on the back is not considered harassment. It may be inappropriate, it may be wrong, somebody might lose their temper and insult somebody, and you need to say, hey, stop that. That's not appropriate. I don't like the way you talk to me. And if the person stops and they say, I'm sorry, I don't have to say they're sorry. You know, I'm in a bad mood. I got out of the wrong side of the bed today. I got in a car accident on my way to work. Shouldn't have reacted that way. Then it's an incident that probably won't rise to the level of a single incident causing that is so severe, considered to be harassment, but it could be. So we look at unwelcome remarks or jokes about race, religion, sex, age, disability, or any other grounds of discrimination that these things threaten or intimidate you. Now, by the way, let's just say, for example, a person underperforms consistently at work because they're an underperformer. And underperforming is not a grounds for discrimination, or prohibited ground. But their coworker constantly insults them because they can't meet quota or because they, don't carry their weight. And they constantly insult them and they intimidate them and threaten them. That's still harassment. It doesn't necessarily have to be about race, religion, sex, age, disability, or any of the 11 prohibited areas. But if it's just two people not getting along, it becomes more difficult to prove. So, but still could be considered harassment, even if it doesn't fall under those areas. So a complaint of harassment must be filed within 12 months of its occurrence and of its last occurrence. So here we've got the series of events or one significant event. The complaint is made within 12 months. And if anything that happened prior to the event, the last triggering event within the last 12 months, anything prior to that is similar to or contributing to or part of this series, then everything before that can be included. But if the last event occurred and more than 12 months transpires, then the Human Rights Commission will likely not hear the complaint. So your complaint has to be real and real enough that sometime within 12 months of the last instance that you file the complaint with them. Now, you know how the courts are and how things are. It might take a lot longer than a year for it to be heard and for it to work its way through. So it's just the date of the last instance to the date that the complaint is filed. And then finally, identifying which of the answers below does not constitute harassment. So this is that negative question. What does not constitute harassment? Discrediting the person by spreading malicious gossip. Already it says malicious. Discrediting a person by spreading malicious gossip and rumors, ridiculing the person, humiliating them, calling into question his or her convictions. That's harassment. A single or isolated incident, such as an inappropriate remark or having an abrupt manner, that is not necessarily harassment. It has to be so significant that it rises to the level of harassment. And so a single isolated incident as an inappropriate remark, they're not describing that to be significant. And unwanted sexual advances, which may or may not be accompanied by threats or explicit or implicit promises. Of course, that's harassment. Making rude or degrading or offensive remarks, that would be considered harassment. So the rude, degrading, or offensive remarks may or may not be associated to one of the 11 areas of prohibited grounds, but if they are persistent and repetitive, harassment. A friendly gesture amongst coworkers, such as a pat on the back, hey, way to go, guy, that's not necessarily considered harassment. Although somebody may not appreciate being touched, they just need to say, hey, no more of that, don't touch me. And so if it's not a regular part of the behavior, then it's not harassment. Isolating the person by no longer talk. So this passive aggressive harassment, isolating them, no longer talking to them, denying them, ignoring their presence, distancing them from others, that is a form of harassment. And we know that some passive aggressive people, that's just the way that they deal with stuff, is they isolate them from everybody else. So both B and E are those. So we're going to take a break. We're going to come back and we're going to talk really quickly about quid pro quo, and then we're going to move on to some other things about employment equity, pay equity, and human rights. So remember, don't turn off. Maybe you can turn off your camera, you can turn off your mute your microphone, take a break. We'll see you back here at 2:46. We ripped you off for a couple minutes again today. We'll be back here at 2:46 and we'll reconvene. Thanks a lot, guys. We'll see you in a little while. Hello, everyone. We're back again. I'm sorry about the short break. Our next Latin expression is quid pro quo. Quid pro quo is exactly means this for that, or something for something, this for that. And so the term quid pro quo isn't necessarily only used in when it comes to sexual harassment, but it is often used when referring to sexual harassment. And it can occur in a workplace when a manager or an authority figure hints at, suggests that an employee gives something in return for something. So a sexual demand or a date or some form of attention in exchange for, say, a raise or a promotion or being treated normally or fairly or given special preference. Changing work standards after an employee consistently refuses a supervisor's or an employee's request for a date would be considered quid pro quo in the form of sexual harassment. Disciplining or firing someone after the end of a relationship. Excuse me. Job applicant who may be subject to this kind of harassment if the hiring decision was based upon the acceptance or rejection of sexual advancement. So quid pro quo is a Latin term. It's used often in law, and it means this for that. So sometimes it's in financial matters. Might be, that someone is given special treatment in a contract arrangement in exchange for something else. And so it's generally used in a negative way and often used to describe sexual harassment. So the Human Rights Act, and I said to you later on, this is going to pretty much explain itself. The Act itself states is a principle that all individuals in Canada should have an equal opportunity to make for themselves the lives that they are able and wish to have. So when a person is capable and wants to have something in their life, but they have not had their needs accommodated when they under a certain area of grounds, the Act is meant to promote this equality by prohibiting discriminatory practices based upon specific attributes such as race, ethnicity, sex, and others that may prevent a person from achieving their capabilities and their wishes. So here we're going to talk about the principles of diversity, equality, and employment equity and inclusion. And, originally this title was just about equity, but we hear very often people talk about diversity, equality, and equity, inclusion, sort of all together. And they all mean something different, but they're all related to each other. But firstly, we're going to talk more specifically, not about the phrase or the terms or the meanings of each of the terms. We're going to talk specifically about a piece of Canadian federal legislation. So remember, when I say that it's federal legislation, it means that it applies to all federal government employees and all employees who are working for an employer who is federally regulated. Banks, airlines, telecommunications companies, railways, interprovincial railways, ports, those sort of industries. So employment equity is an act that requires all employers to engage in a proactive employment practice to increase the representation of all four designated groups. So in Canadian federal employment equity, they talk specifically about women, people with disabilities, Aboriginal people, and visible minorities. And of course, visible minorities could be race, most often are race related and color related. And it's designed specifically to deal with these 4 groups of people so that we do this. We take a look at the community in which we operate, and we ask ourselves, what is the percentage of the population that we work in that are women, that or people with disabilities, Aboriginal peoples, and visible minorities? And then we keep track of statistics. Oh my goodness, statistics in our company, and we ask and we compare and we say, does our company's demographics in these 4 areas closely align to the demographics in these 4 areas of the community that we work within? And if there's a significant or material difference between the community and the company, then the presumption is that there's something taking place in our policies and practices that might be streaming certain groups in a particular way and not coming out with natural outcomes that represent the community. So the Act states that employment equity means more than treating a person the same, because very often we're looking for equality, but this is equity. And they subtly mean 2 different things. By treating people the same way, but it also requires some special measures and accommodations of the differences so that we can start to get some outcomes that more accurately reflect the community. So that little picture there is, I don't know what that little picture is, too small for me to even see. So the Employment Equity Act has a purpose, and that is to achieve equality in the workplace so that no person shall be denied employment opportunities or benefits for reasons unrelated to their ability, and to correct the conditions of disadvantage in employment experienced by women and Aboriginal people, persons of disability, and members of visible minorities by giving effect to the principle that employment equity means more than treating people exactly the same way, but also requires special measures to accommodate the differences. So maybe this isn't a great analogy, but I kind of look at this sort of like a handicap in golf. We've got one person who has all the benefits of having golf lessons and growing up on a golf course and coming through a golf family and a golf community, and all their friends brought them to their out golfing all the time. And we've got a new person who hasn't had all of those experiences, and so therefore different. And so how do we help the person who has got a 0 handicap to have the possibility of having an equal outcome to the person who's got a 20 handicap, the person who's never played golf or doesn't play golf very much? And the presumption is in that analogy that it's likely in most communities that there have been historical differences in the way that people were treated and the opportunities they were given. And so we want to take special measures to allow the people with capability over here to have the same or similar outcome as the people over here by removing the barriers that existed in the past. So they don't require people to, in the federal legislation, they don't require companies to say, oh, I've got 2 people, one fits into one of these designated groups and one doesn't. This one that doesn't fit into a designated group is far more qualified. It doesn't require them to hire the unqualified person. It says nothing like that. It doesn't say less qualified people shall get jobs over qualified people, which often we hear, people say, well, that's discrimination or that's reverse discrimination. What they're saying is we want to do things like have food in our cafeteria that is attractive to and appealing to people of all races, colors, men, women, and that if we only have food in our cafeteria that is attractive to them, then maybe only certain kinds of people are going to apply for these jobs. If we only advertise in certain places, then we're maybe never going to get enough Aboriginal people working in our company. If we only use referral advertising, hiring as our means of referral, or maybe so they say, let's take a look at the outcomes. And if there is something in the outcomes that doesn't balance with society's demographics, then let's change the way that we attract people, that we recruit people, where we advertise, how we set up our company. Have we made our company accommodating to people of different genders and different backgrounds? And so it's an interesting thing, that it's not only important that you identify different ways to remove the barriers, but once those people are attracted to your company, do you create an environment that is inclusive so that they don't isolate and all people of a particular gender sit over here and visible minorities sit over there and Aboriginal people work over here? Have we been able to include people in a way that they want to continue working there, so that over time the organization accurately, its demographics in these 4 areas accurately reflects the communities that we work in? So if you're a provincially regulated company like we are in the staffing industry, but you are supplying more than 100 people in a particular region or office, then you are also required to participate in what's called the Federal Contractors Program. So they basically say, hey, if you're a supplier to us and you supply and you have more than 100 people, then we want you to do the same thing that we're doing. The government says, we're doing this. We're measuring, having people self-identify and keeping it in secret files, and we're doing statistics. And when we see the statistics are out of whack, we try to do things to be more accommodating and more attractive to these 4 groups. If you're going to be a contractor and have 100 or more people working for us, then we want you to have the same program. And so some temporary staffing companies that are working with the federal government have to also have a program. And so that hyperlink that's down there, and it's in the documents that you were sent, is how you get into this website for the English and French versions of how to implement an employment equity program if you're a provincially regulated contractor. So employment equity programs, the law, the federal government program, says we're going to do a workforce analysis. We're going to collect data. And by the way, people fill out forms and they submit them anonymously to a place over here to the employment equity person who doesn't really care about the name. They don't care about who the person is, but it goes into a separate file, so it's not accessed by anybody in human resources or a manager or a supervisor. It's just over there for statistical purposes and doesn't find its way into the mainstream. And people self-identify. So we don't question people. If a person says, I have a disability, and then they have a disability. Nobody goes in there and says, oh, you've identified you, because it doesn't affect them personally. It affects the overall decisions that a company will make to try to be better at representing the community, but it doesn't affect that individual. So a person self-identifies as to whether they are Aboriginal, female, male, disabled, and or visible minority. And then they conduct employment system reviews. So in other words, they take a look at all their policies and practices, and they take a look at their systems, and then they create a plan, step 3, that's going to try to help change, improve, or remove, change the system, improve the system, or remove some of the barriers and some of the issues. And then they put in practice ways to sustain that program. So that's the part that I talk about being inclusive, so that it makes everybody feel like they're included in it. And then they have to submit a LEAP report or an annual report to the federal government that says, we're doing this. The federal government does not say, boy, you guys are failing. They don't go in and say, the community numbers are this and your numbers are that, you're in trouble. They say, are you doing this? And then at any point in time, an employee or people or the and say, hey, we don't think you guys are actually doing this. And then that's where the program comes into play. That's where if a complaint is made, then somebody can go back and say to the company, okay, the complaint really has nothing to do with the individual. It remains anonymous. Let's just take a look and say, are you actually doing the things that you say that you're going to do? So again, these are the types of questions that you get on the challenge exam. Multiple choice questions. Employment equity involves all of the following except identification of systemic barriers to employment opportunities that adversely affect designated groups. Yes, it does. Government imposed quotas. No, it does not impose quotas. Having a difference between society and the community and your company does not translate into a quota. It just translates into information that people can use to help direct them in terms of trying to find out what kind of policies and practices they have in place that might be affecting that outcome. Plans to overcome other employment barriers? Yes, it does. Reasonable accommodation? Yes, it does. Being proactive in planning an annual employment equity program? Yes, if I just said to you, once a year, they have to submit the LEAP program. So some questions about demographics that come into play with respect to employment equity and discrimination in human rights. Some of the issues are that there's things, for example, a large number of baby boomers approaching retirement age, and also the shortage of young people available to replace them, and particularly in certain trades and skills. And so it's kind of interesting, like the demographers have been trying to predict the fact that like 20 years ago, they would say, hey, the baby boomers are all going to retire. We're going to have a shortage of people. When in reality, what's also happening is that baby boomers are not retiring. That people of my age are saying, hey, I feel like I'd like to continue owning my company and operating my business and provide training to people for another 10 more years, until some point in time when I feel like this isn't fun anymore or it doesn't contribute financially to my family. So as a baby boomer, I'm not actually acting the way that 20 years ago they were predicting that was going to happen, is that baby boomers are going to leave. But the reality is that baby boomers are leaving certain professions. So we hear in the news every day about nurses during pandemic who finally said, I had enough. So nurses who've been around for 25 years, who belong to a union, who've got a retirement package, who've met their 80 factor or whatever it is, can get their pension, said, I don't want to deal with this kind of stress anymore. And we didn't have enough young people coming in. We've got other industries like trades. People are not being directed coming out of high school to go become masonry brick makers. If you want to have custom brickwork done on building a whole bunch of new homes in a neighborhood, there's just not people who have those particular skills around, because it's a skill that was traditionally performed by Europeans who came to Canada and brought those skills with them. And we haven't done a great job in training new generations to pick up on some of those very, very important skills and trades. So those are just some examples. And these are the kinds of issues that your company and you as a recruiter and your customers need to be discussing all the time. How do we attract older people to continue to work? How do we attract younger people to come into the workforce? How do we get people trained to fall into some of these trades? What are we going to do about the differences that occur between what's available in the community and what's available in our workforce? So this is for Ontario only, but it's important, and I will go quickly through it, but it's important for other provinces to understand, because other similar things happen in different ways. And most other provinces, very often it's done in little pieces. In Ontario, they did it as one big piece of legislation, but it's called the Accessibility for Ontarians with Disabilities Act. So this act was put out, 15 years ago. And it was like a 15-year transition So it speaks to developing and implementing and enforcing accessibility standards inside companies with multiple milestones throughout the process. So the first milestone was training your employees on customer service so that they understood the language and the obligations, the language that is used and the obligations of employers and the needs of the community who may have disabilities. And then it was the second stage was to design information and communication structure so that your website and your documents and your policies and your training all supported a more accessible workplace. And then it was to address employment, that have we found ways to employ people, and that is all kinds of accommodations with software, equipment, ramps, elevators, braille, large print, signs, voice to text, text to voice, all of these kind of technologies so that we could help to make our employment environment more accessible for people. The big one had a lot to do with transportation. This is where, and the built environment, these are the big and expensive ones. And I'll tell you the story about the transportation system. So, I feel like in these areas, I know a fair bit. I mean, besides the fact that this has always been something that has been important to us in our companies and our corporate culture, I have a 28-year-old disabled daughter who's been in a wheelchair all of her life. She doesn't speak. She doesn't have high cognitive level. She has difficulties with dexterity and a whole variety of other issues that affect her daily living. And she qualified for, as she went to school, for a Wheel-Trans bus or wheelchair bus to pick her up and take her to school. But she's not in school anymore. And so she qualified for, it's called Wheel-Trans or Trans Helping around the Toronto area. There's two programs. Excuse me. For Trans Help in Mississauga, Wheel-Trans in Toronto. So she qualified to get a pass. And, it's you phone and you book a thing in advance and they come to the house and they pick you up. And it's not the most efficient thing in the world, but it is a way for her to get around. But her needs are so significant. She needs a caregiver who would accompany her everywhere she goes. She can't go anywhere on her own. She's not capable of doing that. So the interesting thing was that in the beginning, they said, yeah, you're qualified for all of this, no problem. And then they came along and said, well, we're starting to get some buses that are wheelchair accessible because of number 4 in the AODA. So every municipality and every city was required to start to implement wheelchair accessible buses. And so they tipped and they had ramps and all kinds of fantastic technology. So they came along and said, but she's no longer eligible for Wheel-Trans or Trans Help to come to the house to pick her up because she can go to the public bus stop and she can get on the public bus now because it's wheelchair accessible. Except for I live in a neighborhood that doesn't have sidewalks. I live in an old neighborhood that doesn't have sidewalks. And it's 2 kilometers to the closest bus stop. And in the wintertime, for her to, and she uses a manual wheelchair. So for her to roll through the slush and ice for 2 kilometers to get to a bus stop and sit outside and not have the cognitive ability to even understand that she's freezing to death and she's going to, her hands are frozen, and to keep her mitts on and get them soaking wet while she's rolling on. So, we had to appeal it because the decision that they made, because the implication was that they took it to the letter of the law, that they're going to provide accessible busing to everybody. And if it's good enough for, somebody to walk to the bus stop without a disability, it's okay for a person who's got an aid who might be able to push them through the snow to get to the bus stop. And so we had to appeal that. And so the reasonable accommodation that they made was that she's eligible from November 1st until April 15th to have Wheel-Trans come to the house. And the rest of the time she has to go to the bus stop. So, we saw significant improvements all over the place. And sometimes there was an unintended consequence that was adversely discriminating against her, not systemically, adversely discriminating against her, which required a reasonable accommodation. And then finally, the last part is the physical structures, the buildings. So the elevators, the ramps, the accessibility, the curbs, the things that were in play. So all of those were supposed to, by 2025, all public buildings and buildings with over a certain number of employees needed to have this in place. So the interesting thing that we found in the studies towards creating the act was that 95%, and this also comes out from people who are involved in federal employment equity programs, who are now filling out those forms anonymously and being submitted and going into statistics. 95% of the disabilities that people have or claim to have are hidden, and that their employer or another person wouldn't immediately identify with them as having a disability. And so therefore would not immediately identify that they needed to be accommodated. And so by creating through the AODA and being a great employer who takes these things into consideration, we have to take into consideration that we really don't want people to have to ask to be accommodated. So if we continue to evolve our policies, our knowledge, our documentation and communication, our transportation and communication, and our physical structures, buildings, and tools in a way that everyone has an opportunity to click on the right button or go down that path, that they can be accommodated without having to ask for special consideration. And that's the goal. It's estimated that 1 in 5 Canadians will be 65 or older, so 20% of our population will be 65 or older in 2 years from now. And half of that group will have some form of disability. And if we take a look at their healthcare costs, we know that about 80% of the entire healthcare budget is spent on people 65 years and older. And so we've got some issues with respect to our healthcare plans, because people are working longer in life and staying at work later. We've got some issues with respect to how our healthcare system works and how many beds we're going to have and how many nurses we're going to have. And these are all things as recruiters and people in our industry that we need to take a real interest in. More than 500,000 Canadian adults have some form of vision loss. Yeah, I can't even see without my glasses on. And it's been that way for a long time. So, more than 500,000 Canadians have some form of vision loss that's not corrected by glasses, and more than 1 million live with some form of hearing loss. I believe these statistics are understated and underreported, because I'll tell you what, at my age, pretty much everybody that I know has some form of, is asking to borrow my glasses when we go to read the menu, when we go out for dinner. And hearing loss, not as much, but also hearing loss is one of those things that people who have hearing loss issues often don't even identify it themselves, because it's happening over such a long period of time. Their husband or wife just accuses them of not listening, when in reality, over a long period of time, it's subtly declining. And so the person themselves don't even recognize it unless they go out. Mental illness, we could go on all day long talking about the issues of Bell Let's Talk and who this is affected by. And so it's not only people who have identified specific diagnosed illnesses. It's not just people with Alzheimer's or dementia. This affects all kinds of people of all ages, everything from ADHD in young children and autism, and this massive spectrum of autism, where so many people have got some of the characteristics of the disability or the condition, and that over time in life they change and they evolve, and other people, at the other end of the spectrum, really obvious, to stress and anxiety and tension and phobias and fears and concerns. And sometimes they're temporary, that come from significant losses and changes in a person's life. These are all things that employers, and as friends and as human beings and as family members, that we need to be considering all the time. Again, this is not part of the presentation, but my personal view on this, and it's worked well for me, is that when we find people's behavior, whether it's an employee, prospective employee, an existing employee, friend, family member, service provider. When we find somebody's behavior is not what we might expect, that they're not between the curbs in terms of what you might call normal, predictable behavior. When it seems to be a little bit different, we got to ask ourselves and say, first off, people have different personalities. They have different extremes in certain aspects of their personalities. And sometimes they're outside the norm, but it doesn't mean they have a mental illness or a medical illness. And sometimes people do have a medical illness and they fall within the norms and we can't see them and we can't tell. And it's not for us as employers and as friends and as family members to try to figure it out. But to try to be the doctor to diagnose it. But what we do know is this, that if we know a person has an illness, let's say, for example, a loved one or family member has cancer, and we know that they have cancer, and they behave differently. They become less motivated, or they become frustrated or angry, or they become depressed. We accommodate them. We accept that that's okay. And we do everything we can to try to help them and to make their life better and for it to be more productive and enjoyable. And we try to do the things that we can do to help them be better, or to create an environment that doesn't exacerbate the symptoms that they have, to try to relieve them from their pain and from their anguish. And so we do all kinds of things in the way that we accommodate them, whether it be cooking or cleaning or helping them dress or visiting them or giving them our love. But at work, we tend not to do that. We tend to just say, that's bad behavior, it's unacceptable. And I think that as a society and as employers, we need to start to think about our employees the same way as we think about our non-employees. How can we take advantage of, and I don't like to use the words take advantage or exploit, but how can we allow that personality type or characteristic to thrive in our organization? Where do they fit best? How can we accommodate that disability or that mental health issue or that personality type that gets really stressed or anxious over certain events and things and practices and equipment and accessibility inside the organization? Can we treat people in our business the same as we might treat other people outside of our business, not judging them, but accommodating them? And this is the trick. This is the way that we get our companies to be so productive, to be so effective, to be available to every kind of customer with every need, with every personality, with every culture, with every expectation. That if we are doing that for our employees and they feel included, and they thrive, then we become more capable of being successful business operators. So I'm not going to go on more about this, but, a disability is any degree of physical disability, infirmity, malformation, or disfiguration, conditions of mental impairment, developmental disabilities, learning disabilities, mental disorders, where it's the intermittent or temporary variances in severity that make it difficult for us at work. Because if it's clear to us what a person's needs are, it becomes more clear to us how to accommodate. But sometimes disabilities have ebbs and flows in terms of how they represent themselves. And so a sample of now each company in the documentation stage has to have a policy. So here's a sample statement. The organization is committed to providing exceptional and accessible service for our customers. Our services will be provided in a manner that respects the dignity and the independence of all customers. The provision of services to persons with disabilities will be integrated wherever possible. This is the part where we are accommodating and integrating in a way that everyone has access. Persons with disabilities will be given the opportunity equal to that given to others. to obtain or use the benefit from our services provided by and on behalf of our organization. So this is a policy that I wrote for one of my companies many, many years ago, and we tweak it and change it depending upon what company we're operating and where we are. And with my customers, this is a pretty high level vision type of policy statement. So AODA policies require accessible training policy. They require access to devices and service animals and support persons. They have to have a way to give people notices of temporary disruption. So that means when the elevator's broken, how do we inform people? When there's construction at the front door where the ramp is, how do we inform people? There has to be a feedback process so that people with disabilities can give you feedback on how well it worked for them so you can improve and fix when you failed. And we have to have all of our documents in various formats so that people with varying disabilities can have access to them. So this part here is the diversity, equity, and inclusion part. And so this is just the high level aspect of it. I mentioned to you earlier that there's diversity, equity, and inclusion, DE&I, that we hear these letters, this acronym used all the time. And the employment equity program, the federal employment equity program, was very specific to those 4 areas. But this generic term, DE&I, diversity, equity, inclusion, is what people generally aspire towards, because this is the expression, this is not law. So companies that are diverse and equitable and inclusive are, and I'm saying now what I've just said to you, but are better able to respond to challenges, to win top talent to come work for their organizations, and to meet the different needs of customers. So with the DEI programs and policies and practices in place, Canadian employers are actually considering how to better support their employees more than ever, with a focus on attracting, motivating, and retaining a diverse workforce, which makes them incredibly more effective in servicing a diverse workforce. So diversity often includes things like gender diversity, age diversity, ethnic diversity, and physical abilities or cognitive diversity. So let's look at a couple definitions in that colloquial expression. Equity refers to the fair treatment of all people so that norms, practices, and policies in place ensure identity is not predictive of opportunities in the workplace. So if we can say, if we unfortunately have it said, in our company, women end up over here. In our company, recent immigrants end up in those jobs. And that is where it's predictive of opportunities and outcomes. If we can say with some sincerity that people of all ages and physical abilities and races and colors and places of origin end up in all kinds of jobs in our company, and we can't predict how that's going to outcome, then we probably have got equity in our workplace. So equity differs from equality because it's subtle, but while equality assumes that all people should be treated the same, equity takes into consideration a person's unique circumstances and makes adjustments to the way we treat people. So this is why the federal government employment equity program is called an equity program and not an equality program. So we want outcomes to seem equal or the same, but in order to get that, we sometimes have to overcome some of the traditional, systemic, and historical patterns that have existed so that we can start to kind of create that environment that is now accommodating or different. So having special advertising in special places to attract people that fit into one of the classes will give us equality in the end. So the doing the special things makes it equitable so that we get equal outcomes, if that makes sense to you. Inclusion is my thing. Like, this is where I think once you've done all this, once you've attracted different people into your organization, then it's not good enough to just say, boy, we hired, lots of people that fit into this category. But having people in a workforce where their experiences at the workplace are embrace all employees and enable them to be everyone to be meaningful contributors without siloing people or streaming or pathing people. So companies that are intent on recruiting a diverse workforce must also strive to develop a sufficiently inclusive culture so that once they're there, all those employees feel that their voices are heard, that it's critical in their organization for them to retain those employees, to keep that talent, and to unlock the power of a diverse workforce. And I got to tell you, in 1984, I felt in the staffing industry, we packed 200 people at a chapter meeting in Toronto to talk about this, and it wasn't just what's the nice thing to do, what's the legal thing to do, what are we obliged to do, but it was, how do we thrive as corporations to become the best in the business, to outperform the competition, to grow, to attract new markets, to be exceptional and excellent in everything we do? And the only way that you can do that in Canada with the way that our country is built, a country of immigrants, a mosaic of people, is that we attract everyone so that we can satisfy every customer, and that we get exposure to every technology, and we get exposure to every perspective and perception and every religion and every culture. And when we bring that all together and we have that to formulate the way our company operates with people who know from firsthand experience that we can become exceptional organizations. And companies that stay in a silo, they're going to only attract the customers that touch the edge of their silo. And companies that are so inclusive that they've got perspective on the world, then the world becomes their perspective market. So diversity and equity for all. Today we talked about human rights legislation, employment standards legislation yesterday, employment equity legislation today. I talked to you about AODA and in other provinces, there's all kinds of little things about accessibility. They're all not just in one act, but they're all there. It's all the same thing. These things all come together to play a part in diversity, equity, and equality and inclusion for all. Okay, so our last topic for today is privacy. We've got 15 minutes to cover it. So PIPEDA legislation is federal legislation that was introduced, again, coming out of the Canadian Constitution and Charter of Rights and Freedoms. And so one of the freedoms that we have is we have the freedom of privacy. And so the PIPEDA stands for the Personal Information Protection and Electronic Documents Act. And so this whole notion of privacy became super important when we started to realize that data can be collected, metadata can be collected, and big data can be collected, and cookies and keystroke can be collected, and everything can be collected electronically, and it can be hacked, and it can be stolen, and it can be violated and used in improper ways. And so it becomes, the more we become electronic and the more data we collect, the more vulnerable we become to misuse. So protection of personal information in the hands of private sector organizations and accompanies this with guidelines for the collection, use, disclosure of the information. So PPIDA talks about public and private organizations, and we talk about what to collect and how to collect it, how we're allowed to use it, whether we're allowed to disclose it, and who we're allowed to disclose it to, and then how we use it for commercial activities and protect it. So PPIDA applies to private sector organizations across Canada that collect, use, or disclose personal information in the course of commercial activities. It also, by the way, affects, I don't think PPIDA affects private clubs. And so if you belong to a ski club or a golf club, and it does impact charitable organizations. The law defines a commercial activity as any particular transaction or act or conduct of any regular course of conduct that is of a commercial character, including selling, bartering, leasing of donor membership or other fundraising lists. So it includes charities. Provincial governments have come along, and the federal government basically said this, and they did this, by the way, many years ago with workers' compensation. They passed federal legislation, and they said, and they did this with human rights legislation. They said, hey, we're going to create a human rights law. You can use ours. You can use the federal government human rights legislation. You can use the federal government safety and workers' compensation legislation. You can use the federal government's employment equity legislation, and you can use the federal government's privacy legislation. But they encouraged provinces, because of the uniqueness of the regionality of Canada, to basically take the principles that are passed, that are required by the federal government, and for the provincial government to create their own legislation. So this is an interesting one, because not all provinces and territories have adopted their own provincial privacy laws. Some of them have said, yeah, we're going to use the federal stuff. So Alberta, British Columbia, and Quebec have their own privacy sector, private sector privacy laws that have been deemed substantially similar to PPIDA. And organizations subject to substantially similar privacy laws are generally exempt from federal laws. So if they applied to the federal one, they don't have to apply to the provincial one. They don't have to apply to the federal one too, with respect to the collection, use, and disclosure of personal information. Ontario, New Brunswick, Nova Scotia, Newfoundland, and Labrador have also adopted substantially similar legislation regarding the collection and use of privacy information. They've named it differently. In Ontario, they've broken it down into health information and non-health information. So in Ontario, we've got, it applies to organizations operating in the public sector, but unlike Alberta, British Columbia, and Quebec, it doesn't apply specifically to just private sector organizations unless they're doing business with the government, or unless it's got to do with health information. So in Ontario, they said, okay, regular old private sector organizations don't have an obligation to do this unless you're collecting health information or unless you're dealing with municipalities. And they created another one called the Freedom of Information Act in Ontario, which basically goes the other way. It's saying if the government's doing stuff, we as citizens have got the right to access that information, to ask for it. So, let me say this differently. British Columbia, Alberta, Quebec, and the federal government have got their privacy laws that apply to all organizations, private and public. Ontario came along and said, nah, we're not going to do this to all private organizations. We're definitely going to do it to all municipalities. We're definitely going to have a policy for all government, provincial government, and provincial government agencies. We're definitely going to do it for all health information. So whether it's public or private. So for example, in my home care business, this applies to us because we're collecting health information. And if you're doing a substantial amount of business with the municipality or the provincial government in an area that collects or uses private information, you have to collect this stuff. So we've got different laws, and the uniqueness for Ontario, not so unique because the federal government has it too. The Freedom of Information and Protection Policy of Privacy Act, which it gives regular citizens the right to access information that the government has about spending and policies and people. And so one of the things that came out of this, I think it was an unintended consequence, in Ontario is what we call the Sunshine List. So the provincial government is required now, because they had so many access to information requests that made it through the courts, that anybody earning $100,000 or more in the province, teachers, government employees, politicians, police officers, anybody in the public sector, if they earn $100,000 a year or more, their name and income has to be included in the Sunshine List. Now, the Sunshine List is massive. This decision was made a long time ago when $100,000 seemed to be like a lot of money, and it's not always up to date, and people complain about it a little bit. If it looks like somebody's hiding the information, they complain about it. But a new Sunshine List is published every year. So if you want to find out how much your favorite customer makes in the federal provincial government, then Google that Sunshine List. So the 10 principles of the PPIDA legislation are accountability, that companies must be responsible for everything. They can't say, oh, that was out of our control. That they have to identify the reason for which they are collecting the information in the first place. And then they have to ask for consent. So you guys have all done this before. You're on the phone with somebody and they say, okay, I need you to fill out this consent form, or the next part of this is going to be recorded. I'm going to ask you a specific question and I require authorization, or you got to check the box or something, but there's always a consent portion of it. Then you have to limit the collection of the information to the purpose of which it was intended. So number 2, so you can't ask for more information than what is needed for the purpose of which it was originally intended. And then they have to limit the use of it to only, so now that I've said, okay, I'm going to use this information in order to help find you a job. Please give me your resume. I'm going to use this to help find you a job. And then we ask consent. Can I help find you a job? And can I use this information to help find you a job? And can I send it to the customer? You said, they say yes. And then you keep it for just that. You don't sell it to a credit card company or to somebody else who's marketing multi-level marketing stuff or something like that. And then now that you have all this information in their resume or in their file or in their employment record, that you don't use it for anything else. You don't use it to sell them something else, to promote them, to scare them, to whatever other use might be, that you only use it for the purpose of which is intended to work. So by the way, I was involved in a franchise system, and we had a license to use a name. And then when we left the franchise system, the franchisor said, send us all your files on all your employees. And we said, no, they're still our employees. We're no longer involved in the franchise system. And even though the contract says we'll give you all that, that was on the presumption that you actually bought the franchise from us and you're the new owner. But there was nothing identified in the purpose of us collecting the information that we told to these people. We're going to collect this information and we're going to give it. So say I'm McDonald's and I operate a franchise down the street, then I'm going to give it to head office for them to use and solicit you and market you and do something to you. And so it was never identified as a purpose when we collected the information. We never got consent for people to give it to the other company that happens to be the marketing company. And so when it was asked for it, we limited the use to only the purpose of which it was originally intended. We've got an obligation in the legislation to make sure the information is accurate and remains accurate. We've got an obligation to safeguard it. So this is why when a company, a retail company or something, collects financial information and or other information, there was some kind of dating site a bunch of years ago in Canada that got hacked, and they had to tell everybody they had to send messages to everybody saying, hey, your information got stolen from us. And you might have been trying to secretly date or something like that. And people panicked and freaked out. Ashley Madison, about 5 years ago, was this, and it became like a newsworthy story. And since then, whether it's Walmart or whether it's, the federal government in collecting information for tax purposes, every time they think that somebody's breached their system and they've had a breach in their security, they had an obligation in law to safeguard it. And number 8, they needed to be open and honest and transparent with everyone that their information was or was not safeguarded and how it might have been hacked and how it might have been used. You have to allow every individual to see and review the information that's included in that file. So if you collect information, if someone who's under the law collects information that is protected and they say, hey, I want to see what you have, they have the right to look at it to make sure that it is accurate. Number 6, and 2, to remove consent. Now, you can't remove consent if you're still using the service. So you gave consent, you gave the information. You can't say, oh, I want you to give me a new heart, but you can't look at my blood type. Like, you can't do that. That's not allowed. So, but you can say, hey, I'm out. I'm not going to get a new heart anymore. I'm removing myself. You no longer are my healthcare provider. Give me my healthcare records. We're done. That is allowed. And of course, there has to be a process for people to challenge a company's or an organization's compliance. So what kind of information is considered personal? Well, the normal sense core to age, name, ID numbers, that's credit card numbers, social insurance numbers, driver's license numbers, health card numbers, your income, your ethnic origin, your blood type, your religion, your opinions, your comments, your social status, your marital status, any disciplinary actions that have been taken against an employee in the past, credit files, credit records, loans, medical records. All of these things are considered to be protected. And so for all intents and purposes, if it isn't information that is available in the public domain and they gave it to you for a purpose, a commercial purpose, then it's supposed to be protected. Now, there are certain organizations, like some staffing companies, that are not doing business with governments, that are not collecting financial information, that don't fall under this legislation. Most companies have a privacy policy anyways, and they choose to adhere to it. So they're not legislated to adhere to it, but they do. And once you tell people that you have a privacy policy and you're complying to it, then you're just as legally obligated to continue to do it as you were, as if you weren't originally required to do it. It's kind of like opting in on it. Okay, one of these things doesn't belong. Which of these following statements about consent is false? Organizations can generally rely upon implied consent in order to collect and use information. The consent mechanism chosen should be clear and unambiguous, and consent can be obtained in a number of ways. So number B and C are correct. You can have however a person is consenting, it needs to be clear to them you are consenting. It's not a trick question. And consent can be obtained in a writing. It can be in an email. It can be clicking a box online. It can be a recorded conversation. But what you generally cannot do is you cannot say, if you fail to respond to this by Friday afternoon, we'll consider this to be your implied consent and we'll continue to go forward. That is not acceptable. So you can't say, well, geez, what did you think when you were applying for a job with our company and giving us your blood type? Did you think that we weren't going to use it, or something? Like, why do you think we asked for it? So you can't have something that seems implied in reverse acceptance. When making a complaint, usually the complaint goes to the organization first. And if the organization fails, this is what I call self-directed legislation, which means that the government says, here's the rules, guys, go ahead and follow them. So an individual can make a complaint against their employer or against an organization, and that organization should respond to them in the appropriate way, following all the areas of the law. And if they don't respond appropriately, then you take the complaint to the privacy officer, to the privacy commission. And when the Privacy Commission deals with it, they're going to try to negotiate a resolution. They're not going to penalize people, give them fines, put them in jail, unless they find that in the resolution process, they're disingenuous or negligent or willfully negligent. So, if you keep on saying, yeah, I'll fix that, and you don't, then there can be fines. So we're not going to talk a lot about this because it's not part of the presentation really officially, but keep in mind, social media has everything in the world to do with privacy. When you go onto a social media site, they collect information. Right now in the public is the controversy over the federal government employees having TikTok on government issued phones and devices. And so the federal government is saying, nope, you got to remove it because the Chinese don't have to apply to any of this stuff. They can collect whatever information they want. You're not held accountable. So they're collecting information even on your keystroke patterns, the times of use of the day that you're logged in, how much time you're logged in, who you like, who you don't like, what you post, what you don't post, anything you might have put in your profile. They're collecting all this information, who your friends are, who you follow. They're collecting all this information, and the Chinese government the Chinese have no obligation whatsoever to protect this stuff. And then, of course, we've got North American companies like Facebook and Google, and they're collecting information and they're highly scrutinized. But again, not necessarily going to find themselves following PIPEDA legislation. They're just following the higher principles of privacy. And so, when people are applying for jobs, can we go and, scour their social media sites, look to see what they're doing, get into their private lives, find out about their disability, find out about their heritage, realize how old they are, what age they have, what religion they have. Of course, this is something that we really need to be careful about, because even though that information might be available in the public domain, using that information is very often a violation of human rights because of the type of information you might have access to. And so the important thing for us, particularly in our own companies, is to have very, very well-written, rigorous social media use, access, and information and conduct policies that we can support inside our organization. Okay, so I am not 15 minutes early, but I am 12 minutes early today. I promise you we'd be 15 minutes done. You guys have been super silent today compared to yesterday, which might mean that you're not even there. So I went quick, covered a lot of stuff. Does anyone who's on the line have any questions about anything that I spoke about today? Silence.
I'm pretty good.
I do not, but it all makes sense.
It all makes sense. Okay. Again, it's important that you know that these legislations exist. It's important that you understand the principles of which they're intended to address, the issues they're intended to address. It's important for you to understand higher level issues. I would probably try to memorize the 11 prohibited grounds, but you don't really need to go into a lot of detail about memorizing stuff. The exam is mostly multiple guess. And so, you'll be able to figure it out. If you attended this stuff and it made sense to you, you'll do well. We've got more sessions coming up. There are going to be me again, probably in another session somewhere in business practices and ethics. You'll have some other facilitators. You've got 2 shots at it. There's going to be more sessions. You're probably already registered for them coming up soon, and then they'll be offered again in the fall. But I do want to remind you of a couple things. Number one, if you have any questions, my email address is easy. I got lots of business email addresses. I'm just going to give you the one I've used forever. Goes to the same business accounts. It is steve.jones@bell.net. steve.jones@bell.net. So that goes into all my company emails. It doesn't matter where I am. I'm going to get that one. The other ones are kind of siloed. So, use it. If you have any questions about what we talked about today, or if you have any issues in your company where you want to try to figure out like some good questions today, how do I apply this? What should I do? I'm more than willing to give you my time to help you kind of work through this stuff. Number two is if you've got some questions and you want to send them by email and you don't care if it's private, then we'll protect the privacy of who asked the question. But if you don't care if it's private, copy Jennifer in on the question and I'll copy her on the answer, and she'll take away all the names to protect the innocent. And she'll, give to this group an email back saying, hey, we had a really good question today, and here's the answer that they got. And everybody can get the benefit of that. So you can ask me personally, or you can ask in kind of a more open, but your identity protected forum. Remember to contact the ACSESS office and talk to Jennifer about getting your account set up so that you can get into the ACSESS web user member section of the website and get access to the resources that are there. Also, in the month of May, awesome conference coming up. Registration is open. You can go to the website and you can register as an ACSESS member and get, I think they have early bird pricing. They always have special prices for ACSESS members. Get yourself registered for that. If you are not the owner or the manager and you don't have the authority to just book yourself into it, go to your boss and tell them how you really want to do this so that you can become an outstanding performer and what your dedication and commitment, what it means to you. Get them to turn it into a competition for people to win if they hit certain goals and objectives inside their organization. There'll be hundreds of people there, and it is the only place that you're going to get this kind of information in Canada. And finally, when you do get your CPC, and you will, make sure that on your business cards and on your corporate profile and on your LinkedIn page and on everywhere, you put down with pride that you are a certified personnel consultant. This designation is the only recognized professional designation in Canada in the recruitment and staffing services industry. There's one other private company that fools people. They offer some kind of, they just take a couple courses, then they send you a certificate. And I see people, saying, oh, I'm a registered something. This is the only recognized certification, professional certification in Canada for the third-party recruitment and staffing services industry. Take pride in it. Show your customers that you have made a commitment to your professionalism, to your industry. I do profiling and I do all kinds of consulting for companies. I will tell you that the average new person to the industry lasts for 2 years in their first company. And for there are 60% of people leave their first company within the first 2 years, and 80% leave the industry within their first 4 years. This is terrible. This is like 60% of the people who come to a recruitment staffing services company for their first time don't last more than 2 years, and 80% are gone from the industry and say, oh boy, that was no good. And those of us who stuck around get better and better and better. We learn, we become great consultants to our customers. We are better sellers. We provide better service. And one of the ways, of the many ways, experience is one, school hard knocks, internal training. But one of the ways is our certified personnel consultant designation. It lays the foundation for us to maybe not know everything, but for us to know what we ought to find out more about. Whereas some of those other folks don't even know that these issues exist and that they need to do some more looking into it to become better at what they do. I want you to become exceptional. I want you to become a leader. I would like you to thrive. I want you to get rich too. I want you to buy a big house, pay for your kids to go to university. And you can do that all by your professionalism. And this is the first step. So thank you very much for taking the time to do it, making the effort. And I wish you guys good luck. Take care.
Thank you, Steve.
Thank
Bye.
you. Thanks,
Bye.
Steve. Steve, can I ask you a quick question?
Sure can, yeah.
Thanks. Just in regards to the seminars. And so I know yesterday we had our first one, and then yesterday I found out there was one today. Is next week going to be the same like that? We've got the next 3 come out for the 8th, the 15th, and the 22nd for the Wednesday from 1 until 4. But will there be an additional one for Thursdays? Like, is it every week
No, I
too?
don't, I have no idea how if you've got those other dates, like all of these dates have been published for a long time. And
I
when
only
you
got them today.
Oh, okay.
Yeah.
When you registered for them, like they were all on when you registered for them, they were all on the website. They were all there.
Mhm, mhm.
So I can't explain that, and I'm not responsible for that, but I will say this much, that Jennifer, I've never, in all of the years we've been doing this, have never had this problem. So there was somehow a glitch this time around.
Well, totally
if-
okay.
But
I-
if you've
I
got,
get that.
and so I don't expect it to ever happen again. And if you have those 3 other dates, there are only 3 more. So you're
Okay.
good to go.
I was like, I thought it was once a week. That's a lot of time. I don't know
No,
how
that's
to
a lot
do
of time.
that. I don't
Yeah,
know if I
no,
can move everything around. So
we
no,
kind
that's
of we
perfect.
put the 2 legals together, and then they're, later
Yeah.
on there's another. And then when we get into the summer, we stop. And then in October, late September, we start and do them again. For everybody that didn't get around the first time or needs to pick up 1 or 2 of them to finish again. And then around the end of November, we have the challenge exam for everybody. Now, I might be wrong on that. There might be a mid-year challenge exam for everybody who's done the 5, but I think it's always done in the fall. And then usually at the next spring conference, so this year in Calgary in May, they'll have a special dinner and award ceremony for everybody who got theirs last year, which is another good reason you say to your, hey, I want to go and get my CPC. They're
My
gonna have
boss is
ceremony.
actually speaking at the conference in Calgary.
Ah, there you go. Very
Yeah.
good. So
Yeah.
you got some, I think you might have a good, well, it's good enough for you to speak, but not good enough for me to hear. So play all the cards and try to get them.
Exactly.
But if you've got the other 3, but what you will probably get, and we haven't figured this out yet because this is in my court, we are introducing a new optional one in sales, because there are some people that said, look, we really want a sales session. So you won't probably get that in the first part of the year, but you'll have an option to opt in on it in the second group, the second end of the year. So you're going to be done. You don't have to take that one, but it's going to be made available to you in the fall.
Oh, I'd love to take that one. I'm in sales, so I'd love to take that one.
All right.
Yeah.
Yeah, well, you'll get that one from me. So there you go.
Perfect. Okay, great.
Good. Any other questions, guys?
I have a question, Steve.
Yes.
Not really related to what we did today, concerning the licensing that is coming for the recruitment industry. I
Yes.
don't know if you can answer, but I'm just asking. Does it mean the companies that came in after that did not need the licensing, when they impose this, if you can't get it, then you go out of business?
Yes.
Really? Like, do you have an idea? You've been doing this for a long time. Like, what would they require? Is it just like bringing in some documents?
Well, the one of the more difficult things that's going to happen, but there'll be some vendors that we get in place, is going to be called a surety bond, which is kind of like, it's kind of like a line of credit, so you can get the bank or an insurance company to say, we've set aside $25,000 or $50,000, $25,000 that this company can have access to, like a line of credit, so that if the government ever fines them with something, they know that they're actually willing to pay it. It's kind of like insurance. And there's different ways to go about it. So we're negotiating, or ACSESS is, I'm not, negotiating with the government to get them to accept surety bonds, which is like an insurance form, instead of the bank saying they've locked down a, special line of credit for you. One's less expensive, and insurance companies are easier to deal with. Banks, usually, if you go in and ask for it, they don't even know what you're talking about. So there's going to be that. So companies are going to have to go through an administrative step. You're going to have to prove that you're not in current violation of a bunch of stuff. So you're probably going to have to prove that you're up to date on paying your employer with the provincial government with your employer's health tax, and that you're registered for employer's health tax and workers' compensation. You got all those things in good standing. You're probably going to have to prove that you don't have a criminal record that you haven't been pardoned for, or that you're not a criminal running a fly-by-night company. And then there's going to be just a bunch of certificates. You're just going to have to say, I promise to, act this way in the future. And I acknowledge the fact that if I don't act this way in the future, I can have my license revoked. It's going to apply
I didn't
to,
understand the first point, Steve, about the insurance or the money, the very first one that you said.
that's the one you didn't understand?
Yeah, like what is it that has to be?
Okay, so there's a thing called a surety bond, or there's different terms for it. But basically, a lot of times when you go to get a license from the government, they say, all right, do you have any money? Like what happens if, so they go ahead and say, are you a fly-by-night company? You can't afford to pay anything? I'm going to give you a license, and tomorrow you're going to go default on paying your payroll to your employees, or you're going to cheat or lie or steal because you don't have any money. And if I fine you, you'll not be able to pay for it anyway. So you'll just shut down and open a new company and start again. So what they do is they ask companies to go out, let's just call for now, we'll call it a surety bond. Okay. So they have different terms, different names. And I think they're actually using a different name. So the government will say, you have to prove that you've got this thing, which says you've got $25,000 either of somebody covering you through insurance, or the bank saying they're covering you through like a line of credit that's locked just for this. So it doesn't mean you have to have the money. They have to say it's like a line of credit, right? And they will never allow you to use it for anything else except for this. So you don't pay very much for it. You don't do it because you're not using it. You're not borrowing money. It's just there so that if you go out of business and you haven't paid your employees, or if they're going to fine you and you don't have any money, they can say, we're calling the bond. It's just the same as if, the analogy is, what's that, bounty hunters, on TV, those crazy TV shows.
Bail bond?
Bail bond, yeah, where somebody puts up a bond and says, okay, I'll put up $25,000. And if Steve disappears while he's out on bail, the person who put up the bond has to pay a fine of $25,000. Right? But you've got somebody there, in this case, because it's the government, they're saying it has to be a bank or an insurance company that will cover you in case you get fined and you can't pay it, or you don't make your payroll and you can't pay it to your temps. And so it's like a piece of insurance, that you have to go get. So that's I think the most complicated. The rest is making promises to not violate the law and proving that you're in good standing with the government.
Okay.
Okay.
Thank you.
Like you don't have to have a certain number of CPCs in your company, or you don't have to have been in business for a certain number of years. You probably are going to have to get somebody to sign a thing saying, yeah, I know Lillian, she is who she says she is,
And do you think this shady bond, is it going to be like a fixed amount for all the recruiting?
Every company will be exactly the same. And I think it's $25,000. Yeah. So you don't have to have $25,000.
Then
You
what
have
if
to
you
have-
have the 25,000 that you can prove? Do you still need to go to somewhere to?
Find
don't-
somebody that'll give it to you.
You either, you can go do that, take $25,000 deposit in someplace, and then somebody will give you the certificate. But, most of the time you just go to a bank and you say, I need this. And they set up the facility. It's like a line of credit that you can't access. And it's only there for one purpose.
Okay. Okay, makes sense, yeah.
Okay.
Thank you.
I gotta
Yeah.
hop off.
All right. Okay, guys. See
Thank you, Steve. Bye.
you guys. Thank you.